The Spam Act regulates the sending of commercial electronic messages with an Australian link. That is, the organisation which sent the message is managed or controlled in Australia. In the early 2000s, as internet penetration gathered pace, there was widespread overuse of email in particular for marketing purposes, but also text messages or SMS. Organisations were marketing to email addresses and mobile numbers whether they had consent or not, and there was very little the recipients could do to prevent the deluge of spam clogging up their inboxes. In 2003, the Spam Act came into force to regulate the use of email and SMS for marketing purposes, but also instant messaging channels such as Skype or Messenger. The key rules under the Spam Act are these. The restrictions apply to commercial electronic messages only, so factual messages are exempt, providing the sender details are included in the message. Marketers can only send such messages to people if they already have their express or implied consent to do so. Senders must ensure that it's clear to the recipient which individual or organisation the message is from. A functional electronic means of unsubscribing has to be provided in the message. As we've said, factual messages are exempt, and there are some exemptions for certain types of organisations, namely educational institutions, but only in relation to their current or former students, registered political parties, registered charities, and government bodies. Also, the message sent from these organisations must relate to products or services supplied by these organisations,